welcome during the visiting professors' special lectures given in Collegium Intermarium. And it is my privilege to introduce Dr. Dragan Dakic, who is our visiting professor in February 2023. To shortly introduce Dr. Dakic, who cooperated with Ordo Iuris for a few years during our conferences in the previous years as well. His legal research focuses on issues of human rights, with special attention given to the protection of life, but also to some different issues on the level of public international law that human rights system belongs to, but is often omitted, this level of international public law. Dr. Dakic gained his academic experience at the Faculty of Law at the University of Ljubljana, Institute for German, European and International Medical Law, Public Health Law and Bioethics of the University of Heidelberg and Mannheim, Max Planck Institute for Public Comparative Law and International Law in Heidelberg, and as well in the Institute of Legal Sciences of the Hungarian Academy of Science and the Faculty of Law of the University of Hamburg. So we are privileged to guest you here in the Collegium Intermarium Faculty of Law during this special evening. His publications of various different rights of life, emerging technologies, artificial intelligence, but what is important today is one of his many focuses on the public international law. His special interest given to the law on genocide. And it is very important that we are speaking about the law on genocide and the genocide prevention in Warsaw. Just 500 meters from here, we had this very special place where Rafał Lemkin had his attorney's office. And Rafał Lemkin was the author who coined the notion of genocide. He was a Polish Jew. He was a state prosecutor in the 30s in Warsaw. And he was the author of the first human rights treaty adopted by the General Assembly of United Nations in 1948, meaning the Genocide Convention. So this is a very special place, and this is a very special evening. Let me welcome Dr. Dragan Dakic. The floor is yours.
Dear hosts and dear colleague professors, students and guests, I'm privileged to have you here today, fully aware of the importance of this topic in Poland and countries where I come from, especially because of the fact that the coin or notion genocide was coined by the Polish lawyer Rafał Lemkin, based on the experiences which Polish people had suffered during the World War II. Along to that, today is also one important date of later modern history. On this particular day, in 2006, there was a concluding of oral hearing in dispute between Bosnia and Herzegovina and Serbia concerning the case of genocide before International Court of Justice. So it is important to me because both of these states are actually my states. I hold citizenship of both of them, and during this lecture, my intention is not to go into details of that particular dispute. The idea was actually to demonstrate the concept of genocide and what it was meant to be during the drafting process, but also to cast a glance on the developments before International Court of Justice and International Criminal Tribunals for former Yugoslavia, which actually demonstrate what this notion happens to be. And all of this together in order to provide brief insight into what this notion might be. So through these three parts of my lecture, I will briefly demonstrate positions of the doctrine and the positions of international sources of law, compare them with what we have in practice. So let me start first with the structure of my lecture. First, we will speak about the sources of international law prohibiting genocide. After that, we will show competent bodies, but for the purpose of our discussion tonight, not in general, so the list is not exhaustive. After that, we will show element of genocide for the purpose to demonstrate what I just said in the introductory part. And after that, we will go to the interpretations, meaning what it is, what it proves to be, and what it might be. So, when we are talking about international law sources on genocide and how it was regulated, we can put in this structural or hierarchical position these sources. Of course, the most important source for our discussion tonight and in general in international public law could be considered Convention on Prevention and Punishment of the Crime of Genocide from 1948. And of course, the idea for that convention and how it should be understood was given by the before mentioned Polish lawyer Raphael Lemkin. So after that, not in the chronological sense, but in the hierarchical sense, we have the statute of the International Criminal Court. We could refer it as a Rome Statute. It's how it's referred in the literature. And for the purpose of our discussion, it is also important the statute of International Tribunal for former Yugoslavia. It's not just because it covers the countries where I'm coming from and events which were affecting me also personally, but because the verdicts of this tribunal made significant impact to development of international criminal law. And if we compare it to the contribution of International Criminal Tribunal for Rwanda, of course, the greater significance belongs to this tribunal, even in the formal sense, since this tribunal actually acted as a second instance for the verdicts of the Rwanda tribunal. And so on the next slide, I'm showing what are the competent bodies for the interpretation of those conventions. I have named International Court of Justice for the reasons which I have said, because the convention in its Article 9 underlines that International Court of Justice will be competent for disputes between the states about the elements of genocide on anything which is encompassed in that convention. The next, of course, there is International Criminal Court, and for the statute, it's the so-called Hague Tribunal. This distinction is important for the purpose of discussion that is going to follow. And I decided to visualize it like this because there is some confusion happened in the practice where we have International Court of Justice accepting something which was provided by the International Criminal Court, not exactly International Criminal Court, but step below, the Hague Tribunal. I placed the date here of 2017 because it is the year of its dissolution. So it is important to understand that it was just a temporarily limited ad hoc body with judicial, but also to the certain scope with legislative authority. It is, I'm saying this because when structured like this in the hierarchical sense, there needs to be strong reasons for the higher judicial body to accept something which was originally given by the lower judicial instance. So as to the elements of the crime of genocide, all of the sources which I have enumerated are pretty much similar to one to another. Our difference is mostly in the articles which introduce definition of the crime itself. So we can see that first element is labeled with the Roman phrase mens rea. It means intent, intention, and it's described in relevant articles as intent to destroy in whole or part, which is also very significant. After that, second element are protected groups for the purpose of genocide. So not all groups of people are eligible to hold the status of victims for the purpose of genocide. There is a strict enumeration of those groups as follows: national, ethical, racial, or religious group as such. This as such is actually a quote from the articles, and it also reflects the substance of those groups, but it also indicates relation to the psychological element of the first element of the crime of genocide. So the intention has to be against those groups as such, which means with the features, with those particular features. And as to the also another third element of the genocide, we have actus reus, or the way how genocide can be committed, acts of genocide. So I won't read through them, but killing of the members of the group, and perhaps imposing measures that intended to prevent births within the group might be interesting for our following debate. And when we are talking about genocide in general, it is, like one of the present professors here said, very difficult topic. Although it might look very simple, since it is of the criminal nature, of course it has some common features with other criminal acts. But it is an international crime, and it has some distinctive feature as compared to other criminal acts from the body also of the international criminal law. And it is in the first aspect of it, or in the first its element, it's mens rea, which we will describe in more details a little bit later. At this moment on this slide, I would just briefly describe how drafting process went. For us international lawyers, it is important because when we're facing dilemma how to interpret some categories or some acts from the international treaty, we are also relying on the preparatory works as an evidentiary instrument, which is necessary to reach adequate interpretation of the meaning of the article. So when the Convention on Genocide was drafted, there was not actually much debate on the first element of crime of genocide. The reason for that perhaps could be in the historical moment when it was drafted, nearly after the World War II, because it mostly relied on the principles contained in Nuremberg trials. And there was no much discussion about intention or intent before Nuremberg tribunals. And that might be the reason why we are missing debate of delegates drafting the convention itself about this element of the crime. It was later developed through the doctrine, but also through the statute of International Criminal Court and those tribunals which I named at the beginning. What was the hottest discussion of the delegates within the participating in the drafting process concerned actually the protected groups. Also, I will just try to be short as possible. And there was an idea to introduce different groups within the scope of genocide in order to make this convention more efficient. But just to cast some light on the atmosphere when it was adopted. So it was adopted anonymously in the General Assembly, but in the national delegates were not so anonymous when it comes to the necessity of introducing this convention. For instance, Great Britain thought that we don't need to have such a convention because those crimes are actually criminalized through the national legislation. So the idea was that we don't need to make that step forward because it would create, their arguments were such, it would create wrong impression that we went step further in protecting values such as protected groups or peace, etc. They found it to be counterproductive because it would give fake hope to the people that they are safe now from the atrocities unlike in the past. Of course, such a position was rejected. We have the convention today. The other opponent to the convention which we have today at the beginning was Soviet Union. They considered that if we are going to have such a convention, it should be exclusively connected or linked to Nazis and their regime, because what we have seen is actually product of ideology, Nazistic ideology, and it should be reduced to that historical era. Of course, counter-arguments were very strong against that idea or proposition, mainly because accepting that position would reduce genocide only to the European continent, which was not true. Especially China was against it because of the Japanese atrocities committed on its territory. But also there are historical evidence that genocide was something that also happened before the World War II on other continents, on other different occasions, and the delegates from those countries were also against that proposition. And what would be the most devastating effect of accepting that approach would be actually making it as something of historical value, which wouldn't have executive power in nowadays relations, which was not the idea of the whole system of United Nations and introducing such elements. So the idea was to never see it again. And it was reflected by the majority of the delegates, national delegates, when adopting and proposing it. Also, when we are talking about protected groups in this regard, there were different propositions what should be included or what should be excluded and how to understand these enumerated groups. And in this regard, there was a proposition that we should list political groups, for instance, among those protected groups. The arguments in this regard were that actually the membership in some political option was the reason for the destruction. Those were the claims made by the Soviet Union, also relying much on the practice which happened in the Germany, Nazi Germany, where the members of the Communist Party were exterminated, but also it gained some support from Latin America states, which also had similar experiences of extortion of political opponents. The reasons why that proposition was not accepted is that political groups are unstable, so they do not meet the level of consistency, and it is easily to change the membership within those groups. So unlike the other listed groups where the delegates thought that membership is permanent or at least more stable, they were not in favor of the proposition to include political groups within the listed categories of protected groups. So, for instance, Iranian delegate argued that even though it is possible to change the religion or nationality, almost like it is possible to change membership within the political party, it doesn't happen that much in practice. So the practice also was taken as relevant when building the legal argumentation, what should be included and what should not in the listed protected groups. There were, of course, different other propositions, and the two of them might be just worth mentioning on this occasion, and it is the proposition of United States of America to list economical groups within this protected list of protected groups, which was rejected by the majority of states delegates because they consider it as a reflection of US doctrinal and ideological views. And some even argued that it is contrary to human dignity, that each human life is worthy of protection regardless to the belonging to different economical groups. And also economical groups are not to be considered that stable as it should be required for in respect to the protected groups. And the other proposition came from the group of Latin American states. I think that Peru was the one who proposed it. It concerned mentally disabled persons. So we saw in the practice of Nazism that they were targeted by the regime and that they were actually systematically destroyed as other protected groups. But that proposition also, JNO, needed support to be adopted. And maybe in this regard, that Soviet Union also had some proposition that national and ethical group should not be divided, like it's pretty much the same, which also was not accepted. Maybe it was the same in some parts of the world, but it's not in everywhere. So because the especially Western tradition makes differentiation between nationality in terms of belonging to the one state as a national of it, formal category, from the ethnicity. And also I think that multi-ethnical state like Yugoslavia was, or like Bosnia and Serbia is, also are pretty much close to that reasoning. So we do have now those exclusive groups which enjoy protection against genocide. I'm saying exclusive groups because there were attempts to broader the list of protected groups, but they were not successful. How we came to the rejection of those propositions is based on the preparatory works which I have just briefly described you, how they went in regard to the protected groups. So when we see that genocide is prohibited and it should be prevented against destruction, physical destruction of certain group, we need to first see if that particular group is eligible to be protected under the convention. And that is a practical issue which might bring some disputes, even though it looks very clear from this perspective. But issues also arose in the case which I mentioned, Bosnia and Herzegovina against Serbia and Montenegro, concerned exactly the membership in the group and how the group can be defined. As to the actus reus of the crime, it also was not that much disputed during the drafting process. So I think that this could show us at least general insight into what genocide actually is. And in the next slide, I will just focus on these two elements of this particular crime because they also gain a lot of attention in the literature, but also the practice demonstrated how a letter of the convention was not always sufficient to understand what we meant to protect through the prohibition against genocide. So, in order to meet requirement of the genocide, psychological element has to consist what lawyers call dolus specialis. So that means that perpetrator was not just aware of possible consequences of his acts or was aware that they might arise from his acts. It is required that he intended precisely those consequences which are prohibited under the convention. And at this moment I can say that it was the most difficult element of the crime of genocide because it is the most difficult to prove it. It was not that difficult in Nuremberg process, and that's why there was not much attention paid to it, because there were written orders consisting genocidal intent. They were written and given by the officials of Nazi Germany. So the intention was not that difficult to prove. And that's why the drafters of the convention didn't pay that much attention to this element. Perhaps they didn't understood that in the future that could be very hard to prove. And it is a requirement of this crime, of the crimes, how they call it, because unlike other criminal offenses and criminal crimes prohibited under the international or domestic law, where these two forms of the intention are sufficient, distinctive feature of the crime of genocide is especially precisely in the dolus specialis, which I have described. So also what the drafters might not think of, and we cannot find that within the discussion, is the challenge to define what those groups actually mean. So which criterion to use to define what is a national, ethical, racial or religious group as such. And as the practice showed, there are some additionals to understand those protected groups, and they were in the practice qualified in the quantitative and qualitative sense. I'll come to it a little bit later. So what we came to through the practice is that we do not actually have reliable criterion to establish what exactly is, for instance, a racial group. There is a disagreement in theory which criterion should be applied. I took it as an example because when you say racial group, it appears obvious who belongs to which race based on some biological or physical criterion. So it's undisputable that people with a dark skin are different race than us present here. But it's not accepted actually in the science. They say that race is a social construction, social construct, and it should be understood in that manner. What are practical implications of this? For instance, Rwanda genocide, which happened between Hutu and Tutsi. Those are two groups which have nothing distinctive between them. They're entirely same looking, with the same tradition, same language, same religion, same customs, same folklore, same way of dressing, same way, entirely the same. So the only distinction between them was formal proclamation of membership within one of those groups. So the members of victimized groups were identified with something similar to personal ID, piece of plastic, in which there was written their membership within the group. And now we see how difficult it was to establish if there was a crime or crime of genocide or some other prohibited atrocity. For the context of this debate, it is especially interesting the case which I mentioned brought by Bosnia and Herzegovina against Serbia. Unlike what we saw, that genocide and protected groups were meant to be exclusive groups, in the application of Bosnia and Herzegovina, the group was described or decided in a negative terms, like the victimized group was decided as non-Serbs. In the structure, ethnical structure of Bosnia and Herzegovina, which it was very multi-ethnical at that period of time, under the notion non-Serbs could be enumerated very different ethnical groups. And the application itself consists no actus reus description how those groups, or at least the major group of Croats, were actually victimized for the purpose of the convention. So what was dispute between before the court is the acceptability of recognition to such a group as victimized one. Could it be ethical, national, racial, or religious group? In this moment, when we are talking about the case before the International Court of Justice, it should be borne in mind that International Court of Justice is a legitational court. It's not a criminal court, which is substantively different proceedings, substantively different reasoning between these two instances. What was problematic is actually that the Court of Justice accepted a negative definition of group as non-Serbs, where many Serbs also could be identified within, since they were calling themselves Yugoslavians in that period of time. And that might be one of the interesting developments, what groups were meant to be and what they proved to be. I'm just noting it that practice disconfirmed approach taken by the drafters that those groups should be understood as if they were exclusive. Simply, it was disproven through the practice. What was the next interesting legal point is applicability of law. Why I'm referring to the to the International Court of Justice and at Tribunal for former Yugoslavia is because in the large proportion of its reasoning, International Court is actually relying on findings or interpretations of the tribunal. And it is problematic because when I, at the first slide, among the first slide, showed you the competent bodies and the relevant international law, it is obvious that those two judicial instances were applying different law. So while the court should all exclusively decide about the articles of the Genocide Convention, the verdicts of the tribunal were brought based on the customary law, as it was stated by the tribunal itself. So it was not quite legally justified, easily to justify why International Court of Justice applied different source of law when deciding in the case brought by it based on the convention. Also, there are many problems with evidence accepted by the court. Those were some, let's say, reports of different commissions, which, for instance, one of them concerned the city called Zvornik. The commission stated that Serbian forces killed about 2,500 Muslims in that city, while in the process against Slobodan Milošević, that number was revised and reduced to 40 Muslim men. So the difference is extremely large. Also, there are so many examples where that number, also it should be noted, was given by only one person. So the commission actually made no inquiry to check out these statements. It just relied on the testimony of one person. And a process or case against Milošević is useful in this sense because many of the evidence which were a basis for the International Court of Justice were actually dissolved by the tribunal itself, or the numbers were drastically reduced. And from the legal perspective, I will come back to the first element of intent to destroy. International Court of Justice accepted that genocide happened based on the verdict of tribunal, regardless of all the shortcomings, which I just mentioned, based on the verdict against General Krstić. In that particular verdict, which concerns criminal liability of that individual, not on the dispute between states, is the genocide happening or not. So the tribunal decided that that individual person was responsible or liable for the acts of genocide. And there is one statement of the tribunal which could be classified as obiter dictum, part of the verdict, because it was not the matter within the competencies of the tribunal. It was not something that tribunal was deciding about. At that particular case, it was sort of additional statement to illustrate its arguments. It said, since the Krstić committed this crime, it might be evident that it was a part of the military authorities' intention to commit genocide. So it was like a statement unimportant for this particular verdict, but it was there. Why I'm saying this? It's because the methodology of international tribunals, courts, and different judicial bodies actually applies this way of introducing some legal facts into legal life by obiter dictum. And it also happened here in the very drastic way, because this part of the verdict was something grounds for the International Court of Justice to say that genocide actually happened. In the procedural sense, the larger or the major shortcoming of the process before the International Court of Justice was omission to conduct its own inquiry into any evidence. And this approach was very criticized by the Western scholars, who found that practice of the tribunal was inconsistent in itself and very disputable, which is true, because many of the aspects of the Krstić verdict were not confirmed through the later case law of the tribunal itself. So that was just one aspect how the intent to destroy was understood by the competent judicial body in very extensive way, because state itself cannot be a barrier of this sort of intent. It can be individual. So why I said this was quantitative and qualitative sense were additions. Actually, it is very disputable if the concrete crime, which was subject of the verdict of the International Court of Justice, it's called, perhaps you all heard of it, it's the crime that happened in the Srebrenica. Could it actually meet the criterion of protected group? Because one of the claims of Bosnia in that case was that the genocide was committed against the state of Bosnia and Herzegovina. It's actually accessible to anyone interested to see how they define the group. So the group, protected group, was defined in a negative sense as all non-Serbs and as a state of Bosnia and Herzegovina. State cannot be the victim of the crime, but still it was something acceptable for the International Court of Justice. Later, it reduced protected group to the Muslim population because they were the victims of the atrocities happened in Srebrenica. Why I'm saying these additional elements which were used by the bodies such as tribunal, because they face the problem to qualify events in the Srebrenica as a genocide. What was missing? If we accept, like court did, accepted this wide definition of accepted group, we are still missing in whole or in part. Srebrenica is small municipal in Bosnia, and it was about 40,000 population, Muslim population in it. And what happened is actually after the operation of Serbian forces, not of the states of Serbia, but of Republic of Srpska, they were defeated and captured. Whole civilians were permitted to depart, to leave. But men able for military, in the age for military, were kept and killed. Those are the facts. Nobody denies. It happened very systematically, very organized way. They were separated and they were executed. According to the impartial commissions and the numbers of the victims accepted by the tribunal and the International Court of Justice, it was about 8,000 men were killed on that occasion. The problem from the legal perspective is to subsume it within the concept of the group in part. The situation would quite differ if the victims were all civilians, women, children, etc., etc. Because the Muslim population in that municipal could be considered as a part of Muslim population in general in Bosnia. But they were not targeted victims. The victims was part of that part. And that's how Western criticism refers to the judicial approach to it. Shahbaz, one of the most famous scholars in the field of genocide, international criminal law, who writes much about genocide, says that it is a huge deduction of the protected group. What is the part of protected group which deserves to be protected? Tribunal itself made a statement about it. It found in another case that affected or victimized group presented less than 3% of the Muslim population in total. And they consider it to be insufficient to be qualified as a significant part of the group. So 3% of the total population was insufficient to be subsumed or qualified as a group in part. But number of killed Muslims in Srebrenica is less than 1%. And it was enough for that same tribunal to accept it as a sufficient to be qualified as a destruction of a group in part. And why? It tried to provide some legal reasoning on it, and it has 2 counts or 2 points of that reasoning. I should just mention that approach of the defense advocates was that killing of military able men was for the security reasons, because they were not that distinguishable from the other militants. Srebrenica was seized during the war, and Serbian villages around it, it also was a protected area, should be also noted, and Serbian villages around Srebrenica were often exposed to the attacks from the Srebrenica of the Muslim division situated in it. And according to international independent commissions, there is a pretty much same the number of Serbian victims committed during the longer period of time as compared to those of Muslim victims, which were actually generated in 1 or 2 days. The atrocities, it should be also mentioned, often happened on the Christian holidays. For instance, there was a huge massacre in a village called Kravice on the Christmas Eve, on such things happening, and there comes, some say, sort of revenge. But that was not the thing that the defense said. They said, killing of those men was for the military purposes, for the security reasons, which was not sufficient for the tribunal to accept that argument. But in their reasoning, why they accepted it to be sufficient proportion of the group, they said first reason was inability, as a consequence of those events, inability of Muslims to gain back lost territory, which might be a strategic argument, but it's very difficult to qualify it as relevant for the purpose of convention. And the other argument actually relies to the prevention of birth within the group. They said that Muslim population actually is conservative, and they have custom law which requires women to have settled matrimonial status. And most of the men were declared as forcibly missing and not as a dead, which actually prevented them to continue with the life, because they had an answer in the customary what a widow can do, what divorced woman can do, but they couldn't find answer on their tradition what women can do in the situation when the head of the family was considered to be missing, which is not quite true, but I won't go into details. Those were the reasoning how this part of a group was accepted to be sufficient for the claims that genocide actually took place. I'm saying it for the purpose of in the part of mens rea and the protected group as well. So based on what we have seen, I have just briefly introduced you what the practice taught us that it is possible to do with those strict and hard legal instruments. We can go on what genocide might be. And this is the concluding part of my speech tonight. As I said, the problem with genocide is in proving mens rea, intention, and to precisely define protected groups. As to the intention to destroy, tribunals, I would say now international criminal law practice, accepted so-called additional evidentiary instruments, which connects intention with the produced effects. So intention exists if we have actual results, genocidal results of that intent. It doesn't have to be written anywhere, it doesn't have to be spoken anywhere. They used two instruments in this regard. First one is the scale of committed atrocities, and the second one is discrimination. So if the scale of committed atrocities is large, but it should be borne in mind, unlike it was intended in convention, in correspondence to general population, it could be understood as a large according to some part of the population or part of the part population, so it's very extensive, it appears to be very extensive. So if that proportion is large, and if the victims were discriminated, then it is sufficient to claim genocidal intent. And now when we are speaking about protected groups, I told you how the race was treated. Yes, there might be some common features of the members of the race, but it shouldn't be understood in biological sense, solely on that criterion. It's broader context, social context. And what we have today? We have today proclamation that disability is not just a physical or mental state. It's also a social construction. Do you see any similarities with race? I think there are. And if we are not going to accept Bosnian position to define group in a negative sense, that disabled people are all who are not able, and let's be more strict and accept intention of the original drafters of the Convention for Prevention Crime of Genocide, and let's try to find stable group within the group of disabled. Disability is something can be treated or can be eliminated through the measures of support and social environment, etc. But let's see what at this particular moment cannot be that easily treated. What is the stable group within the groups of disabled? Definitely, those might be Down syndrome persons, for instance, or persons which share genetic malformation. But I took them as an example because they are a large group. And what they're facing? They already had been swiped out of the population of some European countries. They do not exist anymore in Iceland, for instance. And using additional evidentiary instruments applied by the tribunals, we can say that the scale of committed atrocities based on the statistics shows us that more than 90% of pregnancies where the Down syndrome was detected are actually aborted. I'm not saying still it is enough to claim genocidal intent. What do we need? It's second evidentiary instrument, and it's called discrimination. Can we think that those people or those persons are actually discriminated in any way, anyhow? Legal problem to this approach is in the definition of personhood. So before birth, they are not persons and they are not barriers of the right. That's the basic of the legal approach, which is incorrect. Exactly. Persons who are identified as a persons has or have narrower right to life protection if they are disabled, Down syndrome, as compared to those of able body. We can see it through the legislation, abortion legislation across Europe. Abortion is not permitted after the stage of viability in many European states, most of the European states, if the child is able body. But if it is disabled in the sense of Down syndrome, abortion is permitted almost till the moment of birth. It's not my opinion that it's not just I would say just my opinion that it is discrimination. It was also proclaimed to be discrimination by the competent body, established through the Convention on the Rights of Persons with Disability, in respect to Spanish legislation, which also permitted abortion solely on the ground of disability. And also there are some legislative trends in other countries which are examining and rethinking their legislation in this regard, mostly because they consider it and they find it to be discriminative against persons with disabilities. So, do we miss anything? Are we missing anything to claim there is a genocide against those people, against those persons? Perhaps it is early to say so, because the attention is much more requiring than this which I have described, and there are other additional instruments which might be applied to the present situation before we claim genocide is ongoing. But it is interesting to put this reasoning in the context of obligation to prevent. Also, case law of the tribunals and especially of the International Court of Justice in respect to the obligation of Serbia can provide us some insights into it. And because of the lack of time, I won't go into elaboration of details, but there are firm legal reasons to claim that states are obliged under the part of prevention from the Convention, in the sense of prevention, at least to reconsider their legislation in this regard. So what do we have? What we can be sure that we have? We do have evidentiary instrument which is the purpose to prove mens rea, and it's called scale of committed atrocities. It's happening, actual consequences of such legislation is distinction of those persons. So the group is largely reduced and expiring. Scale of committed atrocities is not 2%, is not less than 1%, it's more than 90%. And the other aspect, another evidentiary instrument is discrimination. It's confirmed to be discrimination, not just by the scholars, regardless of their background, liberal or conservative, almost anonymously those who go into details about discussion accept that this is discrimination. And we do have a group which is suitable to be fitted within the notion of racial group, for instance. Since we saw that international law is willing to accept very extensive interpretation of the victimized group in even negative definition of it. So basically that would be it, what I wanted to share with you on this occasion, and to demonstrate how a law is developing from what it was intended to be toward what it might be. Unfortunately, scholars who are aware of this possibility to develop law in this direction are mostly passive, and methodology which is used to create law by the courts and different instances is often used by different camp of debate, and that's how we came to have many so-called new rights within the corpus of human rights, etc., etc. The idea was to demonstrate how we can use the methods which are already served on the table to direct process in the way which is according to the understanding of law as it should be. Thank you. I would be happy to hear some questions and debate. I have a personal custom to say, if there are no questions, so that means you were not listening. Very careful.
For sure, at least one question from myself, and then we'll accept some other questions also. You already covered one of the topics that was very important for me, meaning this declaration of Iceland that they have cured Down syndrome by, in fact, eradicating the barriers of the syndrome, the people with Down syndrome from their population. But there are still some other very important questions. The second one is about retroactiveness of obligation to prevent genocide. The retroactiveness of the convention, of the treaty. Because the prevention of genocide is not only based on a treaty, the prevention of genocide is also jus cogens, is also a peremptory norm. For those of you who have not been following the second year of law faculty course on international public law, the peremptory norms are norms that are binding universally, even though they were not accepted in a treaty by one of the countries, one of the states, to say it simply. And peremptory norms, if they are accepted as peremptory norms, may be retroactive. So the question is, should we perceive, for instance, Holodomor or Armenian genocide in 20s as a genocide under the convention because of this function of jus cogens as the convention was accepted? Because there were numerous acts that would have been interpreted as being genocidal if the treaty was there, if it was accepted 100 years ago, 200 years ago, or even 500 years ago. We may even believe that the Aztec Empire was committing genocide as well. So the question is, may we use the convention to qualify some of the atrocities of the past as genocide under the convention?
Thank you for that question, which is very interesting from the theoretical perspective as well. And it would be handsome, actually very handy to connect it to the issue of responsibility and reliability. So the scholarship is differentiating between different sorts of liability arising from the convention. And foremost of them is, of course, legal responsibility, personal responsibility. But there are other sorts of responsibility, like moral responsibility and ontological responsibility and other forms of responsibility that are arising from the convention itself. So there are atrocities from the World War II, also like concentration camp Jasenovac, for instance, where many hundred thousands of Serbs were killed by the Ustasha regime. Also similar process happened in the Kosovo as well, where Serbs were the victims, which also could be qualified as an obvious genocide, with detention, which is undisputable part of policies, etc., etc. So in that sense, I believe that there is enough space to qualify those events as a genocide, invoking at least moral responsibility of the actors that committed it. So basically my answer is yes. The issue which might be posed is sort of a responsibility that could be invoked against perpetrators.
I'd like to ask about situation in Nigeria now. In my opinion, all these three elements are fulfilled now in this situation, and it's being investigated for years by the prosecutor's office of International Criminal Court. but actually nothing happens. In your opinion, there are committed crimes, maybe just usual crimes, maybe crimes against humanity, or maybe it's genocide crime. Thank you.
Before you leave, please stay here because I might have questions for you. In Nigeria,
Yes.
when the events happened?
There are crimes committed by Boko Haram.
So, I'm not precisely aware of those atrocities, and I haven't had chance to investigate about them. So it wouldn't be much serious for me to comment to them.
Okay.
But I'm willing to accept your approach that if you consider that there are elements, they of course should be.
I just want to compare the situation and all these elements to the situation which is happened in Nigeria now, where Christians are killed. There are so many atrocities for years committed by Boko Haram, by Muslims.
Yeah,
Okay.
yes. It rings me a bell. I didn't pay that much of attention to it in the sense of my in academic research into the question. I heard about it from the media outlet, something. And yes, at least we can be sure that there is a protected group which is victimized and systematically targeted. But if we would be willing to claim genocide, we would have to have the other elements fulfilled as well. So I'm pretty much sure that today nobody is that, let's say, uncareful to issue some written order of extermination of any group. But if the atrocities are happening based on the discrimination and in the large scale, then we might claim it is actually happening ongoing according to the accepted standards of international law. Why that, for instance, claim of discrimination is really a tricky one. For instance, could be the members of the same group discriminated one against another. According to the tribunal, it might be even possible because next municipal to the Srebrenica was Žepče. It still is. And it's majority of Muslim population, and no atrocity happened there because there were no military threat. So were the Srebrenica Muslims discriminated against their own members of a religious group from the neighboring municipal, or is it acceptable from the international point of view? Thank you.
Do we have any more questions? Sebastian.
First of all, thank you so much for this interesting lecture. I wanted to refer to an episode, a very difficult episode of European history, mostly I would say Polish history. Namely, it's a massacre of Poles living in the USSR in the 1930s. Between 1937 and 1938, about 1/3 of Polish citizens living in the USSR were exterminated following an order by Stalin himself. And I wrote an article myself about this, which I will maybe just quote. I inspired myself a lot by a Polish professor, Andrzej Nowak, who is probably the best specialist of the Soviet Union, in my opinion. And in his opinion, this massacre could be, or maybe should be, considered as a genocide based on the fact that Poles as an ethnicity or as a nationality were targeted, but not necessarily based on factual data. So, what he explains is that the Soviet officers were basically taking a notebook of, the population, and said, oh, this sounds Polish, okay, we will go there and find them, So, I was wondering, in your opinion, could that be a potential qualifier to be considered as a genocide? Because I don't know if you're familiar with this episode. It's very much not known even in Poland. That's why it's all the more interesting in my opinion, because the total of people massacred, according to the NKVD's own data, is exceeding 111,000 people, which is virtually several times the Katyn massacre in numbers. So I was wondering about your opinion. What would be the conditions to be fulfilled so that such a massacre could be a potential candidate to qualify, once again, quote unquote, to be a genocide? Thank you.
So, since Polish and Serbian nation are actually sharing painful experience for the World War II, our scholars are quite often referring to some events in Poland, and I am aware that there was some atrocities against Polish people, like forcible resettlement of more than a million of Polish people within the Soviet Union, and when the German attack on Soviet Union began, I learned that there was more than a million of Polish people resettled to or sent to Siberia. So yes, and those were all issues that delegates of Soviet Union had in mind when they were drafting the convention itself. So perhaps the idea of the convention itself was not to cover this particular or similar events, which were not missing, we are all aware of it, because of the proportion of the group. But what could actually stand against this approach is the practice of the tribunal, which actually defined that proportion very broadly. And another thing, it's not just I would say, wrong approach of the tribunal. There is also a qualitative criterion. So which members of the group were killed? It is very important, because if you take off the head of the group leaders, the number doesn't have to be that large. It's enough to qualify it as a genocidal act. So if you are actually exterminating one group from specific geographic region, then, which is actually within the different state, maybe criterion of total proportion within the general population is not applicable. It is applicable how many of them actually lived in the particular area. So I think there are actually some grounds to qualify it as a genocidal act. But of course I would need to have more information on it. But based on what I have just said, that was accepted by the international law, it wouldn't be impossible. We have already seen something similar happening, especially if the victims, so if there is a qualitative element missing, like you said, that they were not members of the elite, Polish elite, they were ordinary people. Then you're coming to this quantitative criterion, which actually proves that intention was to destroy the group as such, if the victims were women as well, if the victims were children, it's obvious proof. But also the case law of the tribunal provide us with another element that might be qualitative, sufficient to qualify some act as a genocidal. They said that killing of armed men able to be in military, actually could be understood as a genocidal intent, because when you eliminate them from the population, as we've seen, population might not be able to reproduce, so they are going to expire. But it's not what I want to emphasize on this regard. They said if you eliminate that man from the population, then that group becomes vulnerable to different sorts of threats, which you're actually leaving them in the conditions unable to survive, which might not be that legal, close to the legal argumentation, but still, it is written at least as a obiter dictum of one of the verdicts, and as I have demonstrated, it can be enough to constitute the whole approach to the issue.
I have a question regarding the situation in Ukraine, because nowadays it's one of the most topic situation in a place like Bucha. I know that we haven't got all of the information what was happened, but still we have some proof that the men, women and the children was dying there. And my question is, because we know about the genocide, and who will take the responsibility for this? Yes, because we know that soldiers was shooting to the civilian, but what should be happened if we are talking about the Russian government or some proof that somebody give the order? Because you mentioned before that probably nobody would like to sign some document. So there is some possibility to know, to find some information. This is my question. Thank you.
Thank you for this question. I expected actually that the issue of Ukraine is unavoidable at this current situation. But I will just briefly recall on I would say my personal experiences, because I actually lived through all of that. Till the age of 14, I was already a survivor of 2 wars. So we saw that how things are presented in media and what in fact is happening. And well, some things are simply, some atrocities are misused for the political and propaganda purpose. I'm not saying that the Bucha is the case. I'm just saying that it should be very careful when saying something about the events. For instance, there is one case which might be, I'm not saying to Bucha, but comparable to some cases that are currently ongoing. It happened in Kosovo, in the place called Račak. It was a stronghold of a terrorist organization called Kosovo Liberation Army. From that point, they were attacking Serbian villages around and also bringing Serbian as hostages in that stronghold. And during the military and police operation against that stronghold, they all were killed. And there was a present international commission, fact-finding commission, which actually didn't want to access to the spot. They were observing the event from the neighboring hill. And after the operation was finished, they were invited by the officials to come and make report, which they didn't. They just went away. After a few hours, security forces retreat from the position, but the fact-finding commission came next day, and they found civilians, all military abled, like as if they were victims of that event. And there was a report of that commission, and there are some testimonies, even written testimonies, of the members of that commission, how that report was written and under which pressures. That report and that event resulted with NATO aggression against Serbia and Montenegro. But that report and that event were never used in the process against Slobodan Milošević, because they were, from the legal perspective, failure, unuseful. They were not qualified as certain enough to be used as an evidence. So you see what is the actual, what happened and how it was used, what consequences came, but later it was not happened like it was written and as it was in media across the world, but who cares now? I'm just saying it should be careful when we are talking about ongoing events, because we will know what happened at least 10 years later. And if we are talking about criminal responsibility, I would say that based on the experiences of dissolution of former Yugoslavia, we can see that Western part of the world, or Western collective, is seriously preparing arena or arguments or environment for some sort of the legal process. we will see against whom and at which level, and is it possible in practice, it's all unsettled at the moment. But what we can see is serious preparation for something like that to happen. So I don't know if you're happy with the answer, or I can go further in discussion.
I think we will discuss this in the lecture.
Okay, thank you.
Just to add a few arguments, last year in June we published a report of Ordo Iuris on the possible genocidal qualification of the actions of Russian Federation in Ukraine, saying of course that it is too early to say anything now about the legal qualification of the actions and atrocities. They happen not only in Bucha but also in many other parts of Ukraine. And also there is a long-standing, long-lasting controversy about genocide. On the journalist level of analytical approach to wars, civil wars, conflicts, we would like to name genocide every atrocity that happens. Because as it was said by Winston Churchill, genocide is the crime of crimes. At the same time, in fact, what was perfectly introduced today by Professor Dakic, genocide is very strictly defined, and many atrocities that are war crimes or crimes against humanity and that deserved some international criminal responsibility of the actors are not genocide. And of course, many people feel disappointed about this. From the legal point of view, they should not, because it is a legal field and a legal definition. And of course, we all feel that this definition from 1940s is not perfect. Even Rafał Lemkin himself said that he lost the battle on drafting the Genocide Convention. Rafał Lemkin himself, he said that he wanted a lot of other elements to be there among those factors, among those qualificators described today by Professor Dakic. For instance, when we spoke about Actor Reus, he said the destruction of cultural heritage should be there. And it was what Soviet Union did with Tatars and others, destroying the cultural heritage without killing people from this ethnicity. They destroyed the ethnicity itself by cultural barbarism, as Rafał Lemkin will describe that. So, of course, it is up to us, the lawyers, and to the practice of law that was so so perfectly described by Professor Dakic today, this evolution of the genocide doctrine by jurisprudence, by lawyers, by practice, to add on new elements to the doctrine of genocide, to think about those unborn who were killed because of the Down syndrome, to think about other groups and minorities that are persecuted, that are killed, and in fact, that fall victims to the genocide. But also, even in former Yugoslavia, in Rwanda, it took years after the peace arrived there that the perpetrators were sentenced. So even now, of course, we know that in Ukraine, atrocities are happening. Either are they war crimes or genocide will be decided by proper international tribunals, probably not the International Criminal Tribunal, because it has no jurisdiction over Russian Federation, but probably some other ad hoc tribunal that may be introduced by United Nations, by some other international efforts. Professor Dakic, thank you very much for the wonderful, great lecture you gave today in the Collegium Intermarium. I'm especially happy about it because I give lectures on international public law to our students, and it was a wonderful experience to hear about international law, about the Convention on Genocide, from the perspective of the practical evolution of its norms. Thank you very much.
Thank you. Thank you for those nice words and comments and for your questions, dear colleagues. It was really my honor and pleasure and great responsibility to speak here in Lemkin's own town and nearby his former office about his idea and fruits and seed he planted in 40s. But just to conclude about the evolution of international law in general and this concept of genocide, maybe some 30 years ago, one of Serbian famous scholar from the field of international public law, Smilja Avramov, one of the greatest our scholars in that field, wrote that genocide is like malignant disease. It shows itself only in the final stages. So it's like a fatal disease which is not detectable at early stages. We can detect it only when it manifests itself in the final stage, which is pretty much according to the Lemkin's idea. And on that occasion, she proceeds that nowadays, 30 years ago, nowadays the tools of genocide are being much more sophisticated than what we have seen in the history. Imagine it nowadays, what they look like. So thank you once again.